Good evening, viewers. You're watching News Today at 9 p.m. I'm Preeti, Choudhry. Our top focus is that contentious bill that the government tabled in Parliament this afternoon, sent to the JPC but caused quite a furore. The Modi government bringing in a minister disqualification bill is going to be our top debate this evening. Crackdown on criminal netas or draconian law. Also on the show later, can India trust Trump ever again? Well, we are joined by former National Security Advisor in the first term of President Trump. Do stay tuned for that. All right, viewers, high voltage drama today was witnessed in Parliament when the Home Minister introduced 3 amendment bills that could radically alter political accountability in India. The introduction of bills to remove Prime Minister, Chief Minister, ministers on serious charges invoked massive protest and fiery exchanges in the House. Take a look at this report.
महोदय, मैं प्रस्ताव करता हूं कि भारत के संविधान का संशोधन करने वाले विधेयक को पुनर्स्थापित करने की अनुमति दी जाए.
Amid sloganeering, Home Minister Amit Shah at 2 p.m. on Wednesday sought the permission of Lok Sabha Speaker to table 3 amendment bills. The bills added to the House agenda last night proposes sacking of the Prime Minister, any Chief Minister and any minister at any level if they jail for 30 straight days in a case that attracts 5-year prison term. If passed, the proposed law will apply even if the office holder is not convicted. According to the bills, the sacked Prime Minister, Chief Minister or Minister can be reappointed to the post once they are released from jail. The opposition leaders were up on their feet right away.
This bill clearly violates 74(1). Sir, this is the 1933 Gestapo when Gestapo was found in Germany. This government is hell-bent on creating a police state. This will be a death knell and leash an elected government, sir. Indian constitution is being amended to turn this country into a police state.
You are innocent until proven guilty. This bill stands that fundamental maxim of jurisprudence on its head. It makes an investigating officer the boss of the Prime Minister of India. This bill opens the door for political misuse by instrumentalities of the state.
The House also saw an angry exchange between Congress MP K.C. Venugopal and Amit Shah.
This bill is to sabotage the federal system of this country. This bill is to sabotage the basic principle of the constitution of this country. Sir, BJP people are telling this bill is to bring morality in politics. Can I ask a question to the Honorable Home Minister? When he was the Home Minister of Gujarat, he had been arrested, sir. Whether he took the morality of that point of time.
माननीय अध्यक्ष जी, मैं रिकॉर्ड क्लियर करना चाहता हूं. मुझ पर झूठे आरोप लगाए तब अरेस्ट होने के पहले मैंने नैतिकता के मूल्यों का हवाला देकर इस्तीफा भी दिया और जब तक मैं कोर्ट से निर्देश नहीं हुआ, कोई संविधान पद मैंने स्वीकार नहीं किया. ये क्या सिखाते हैं नैतिकता में? और मैं तो चाहता हूं कि ये नैतिकता के मूल्य बढ़े. हम ऐसे निर्लज्ज नहीं हो सकते कि हम पर आरोप लगे और हम संवैधानिक पद पर रहें.
When the Home Minister introduced the bills, several opposition members tore up the copies of the bill and entered the well. The bills have been referred to the Joint Parliamentary Committee. And to become law, some of these provisions would need 2/3 majority in Parliament. In effect, it will take some time before the bills are taken up by Parliament. Bureau Report, India Today.
All right, joining me now is Lok Sabha MP Manish Tiwari. Mr. Tiwari, the opposition has, of course, gone at lengths to oppose this proposed bill, which has gone to the JPC. One of the main reasons that it is being contended, especially where the government comes into question, is that it will equate the chief ministers, cabinet ministers, and even bring the prime minister in the ambit of justice, equate if a civil servant can and has to step down post 30 days. Why not a chief minister or a cabinet minister? Why should you get special privileges?
Well, first of all, thank you very much for inviting me on your show. I think the issues are far, far more fundamental than the ones you outlined. And since I was one of the people who opposed the bill very strongly in the Lok Sabha today, let me outline the reasons. The fundamental maxim of the rule of law, which is basic structure of the Constitution, is that you are innocent until proven guilty. So therefore, there is an implicit and an explicit presumption of innocence till the time a court does not convict you, and that conviction is not upheld by the hierarchy of courts all the way up to the Supreme Court. So under those circumstances, merely because an FIR has been registered, and there are all kinds of malafide and vindictive FIRs which are registered in this country, and just because a certain investigating officer, perhaps on a command performance, decides to arrest that person, to then imply guilt and say that you have to step down, is peculiar constitutional morality. And whenever we've tried to impose constitutional morality by the force of law, it has backfired. The classical case is the 10th schedule, the anti-defection law. It's been on the statute book since 1985. Has it stopped defection? No. Defection from a retail activity went to a wholesale activity and then has become a mega mart. You introduced the voting for the Council of States by a show of hands. Has it stopped allegedly people of very questionable credentials from coming into the Council of States? The answer is no. So under those circumstances, morality is something which is intrinsic to the mental makeup of the person concerned. You cannot impose spurious, law-driven morality for the simple reason it doesn't work. And number two, there is Article 21 in the Constitution, which is the due process clause, and which clearly says that you cannot be deprived of your life and liberty except in accordance with law. So therefore, an FIR, an investigation, even an arrest, even the framing of charges is not any explicit presumption of guilt. In fact, you plead not guilty only when charges are framed against you. And here you are opening the Pandora's box of misuse of state instrumentalities. Register an FIR, arrest that person, keep him behind bars for 30, 60 days, and remove him as a minister. You've seen what has happened. Many of these cases have been based upon, on a foundation of sand. People have been behind bars for 2.5, 3 years. Then closure reports are filed. There is no compensation for the loss of reputation, for the loss of, for the personal injury caused, for the trauma caused to the family. So where are we going by completely overturning fundamental jurisprudence which runs across the gamut of natural justice, across legal systems in the world? That's the issue.
But Mr. Tiwari, you made your point there. The government says that this is public morality, probity in public life. It goes against the grail of natural justice, which you just pointed out, innocent until proven guilty. The larger question also, sir, because this is something that your own political party has raised, opposition parties have raised. We live in a time of constant allegations where agencies are allegedly being weaponized. Do you see then agencies like the CBI, like the ED, even lower courts become political actors?
Well, I would like to take the courts out of that list which you have just elaborated. But insofar as the instrumentalities of the state are concerned, look at their record of conviction. Ask the agencies of the state how many cases they filed and how many convictions are ultimately upheld by the Supreme Court. The answer would be there in front of you. In the case of the Enforcement Directorate, many members of Parliament have asked questions with regard to the final conviction rate, not the conviction rate in the court of first instance, but upheld by appellate courts. And if my information serves me correct from the top of my head, that number is abysmal. I remember many years back, I had asked these same questions because I had brought a private member's bill to provide a proper legal architecture for the Central Bureau of Investigation. Those numbers were absolutely not encouraging at all. And weaponizing of the instrumentalities of the state, law enforcement, and other agencies is not something which the opposition is saying today. It is what the highest courts in the land are deprecating. So therefore, by trying to infuse a false sense of constitutional morality, what you are doing is you are making an investigating officer or an SHO the boss of even the Prime Minister of India. Here, the implications are so portentous that they are even incomprehensible at this point in time. I don't think that this bill has been thought through at all.
But, Mr. Tiwari, okay, I'll give you an example. The United Kingdom has something called a ministerial code, which expects ministers to resign after breaching public trust, and many in recent history have done exactly that. Because most ministers now, even chief ministers, choose to brazen it out under the garb of a witch hunt. That's the reason why the government feels that time has come for a bill like that to be in place. If UK can have an understood, accepted ministerial code, then why not India?
For the simple reason that there is no witch hunt in the political system of the United Kingdom. They have.
But Mr. Tiwari, isn't witch hunt subjective?
Well, that is exactly what I'm saying. Witch hunt is subjective. And so therefore, when weaponization of state instrumentalities, political vendetta, and I'm not talking about the central government at all. Unfortunately, this malaise has also percolated to the state governments. Under those circumstances, if you would have had a level playing field, in fact, any minister or any public servant, actually would have voluntarily stepped down, right? In fact, as I said, morality is absolutely a personal conviction. And therefore, if someone feels that as a public servant, he should not be holding an office, that you should leave it to his prerogative. If you try and make it driven by law, in fact, what you're doing is incentivizing the witch hunt, which you earlier referred to.
But Mr. Tiwari, nowhere does the law state that the government itself, if the chief minister has to step down after 30 days, nowhere does the bill suggest that the government itself needs to be dissolved or step down. The chief minister can appoint somebody else, and after he's acquitted, he can come and take office again.
Well, in fact, that is the other anomaly with the law. It does not say after you're acquitted. It says once you are released, you can come back and take oath. So therefore, the presumption of guilt, which you are ascribing to that person, that, if you are arrested, it is as if you are quasi-convicted. And, that quasi-conviction is that, if your arrest period is beyond 31 days, you have to step down. And the moment you get bail, you can come back and be sworn in as a minister. So therefore, ultimately, this is neither here nor there. I could have understood that if you would have said that, let's say post acquittal, a person can come back. But in India, the reality is the process is the punishment. If a criminal case starts against you, it is not only you, but your coming generations, for 3 generations will keep fighting it. So in India, unfortunately, conviction is not the punishment. It is the process is the punishment.
The
So
question
look
I'd
at
like to
the
ask you.
look at
Right.
the figures in Indian jails. Almost 88% people are under trials who do not have the money, to furnish bail so that they
But
can
then,
come out
Mr.
of jail.
Tiwari, the same yardstick is applied to civil servants in this country.
Well, so therefore,
What makes our chief ministers and even the prime minister so special?
so therefore, in fact, according to me, that presumption of guilt, which is applied to the civil servants, is also wrong, because it is not only politicians who are subjected to witch hunts. People who are sitting in an administrative authority, who are taking decisions day in and day out, if you do not provide them with some kind of protection and insulation, and that is why the Prevention of Corruption Act was amended and 17A was introduced as a safeguard, nobody will be able to take a decision. Because let us suppose you take a financial decision of some import, and you obviously have somebody who is going to be benefited and somebody who's going to be
Well,
harmed.
not just long drawn out court cases. There are problematic laws like the PMLA, which where somebody can be denied bail for full 30 days, and then automatically the person would need to step down. But I'll ask you a larger question, Mr. Tiwari, and that question comes in from, it's gone to the JPC, but wouldn't, you're a lawyer, in your belief, wouldn't it require two-third majority from the House for this bill to pass, as it's a constitutional amendment?
Well, that's the oxymoron. So the constitutional amendment will require two-thirds, but the Union Territories Amendment Bill and the Jammu and Kashmir Reorganization Bill would only require simple majority. So had it been a case whereby it was restricted to a constitutional amendment, since the bar of two-thirds is fairly high, it could have merited some discussion in a joint parliamentary committee to try and see what are the pros and cons, weigh the arguments on both sides. But here is a case even where if the constitutional amendment fails to pass muster, the other two bills will pass by simple majority. And as I explained right in the beginning, you cannot turn fundamental jurisprudence, which is basic structure, rule of law, parliamentary democracy, collective responsibility of the cabinet to the legislature, removal from the legislature on conviction. All these constitutional safeguards cannot be thrown to the winds.
Okay, but I'll come back again, Mr. Tiwari. So, two-third majority would be needed for passing this specific bill. The other two is simple majority, but a special majority would be needed in this. Correct, sir?
Yes, for the constitutional amendment, you require a two-third present in voting.
Is there a grey area? Because if you look at, the abrogation of Article 370, that actually happened with a simple majority, and that was a constitutional amendment.
Well, so therefore, Article 370 was not a constitutional amendment. Article 370 was actually a resolution which interpreted,
because it was temporary in nature,
Constituent Assembly to mean Legislative Assembly, and the Legislative Assembly, because it stood dissolved, Parliament stepping into its shoes, acting as the Legislative Assembly, and then abrogating 370. That also is an irregular procedure, which frankly has been held to be ultra vires by the Supreme Court, that you cannot use an interpretation clause and amend the Constitution.
Mr. Tiwari, can the grey area of a joint sitting route be taken in this? Because Article 108 is a little unclear on that front.
Well, in the sense, you can have a joint sitting of both the houses. If I recall correctly, when the Prevention of Terrorism Act was passed during the NDA-BJP government, they perhaps did not have a majority, constitutional majority or a two-third majority in perhaps the upper house, and there was a joint sitting of both the houses. So yes, all those possibilities are there, but we are not there as yet. How can any government actually bring in a bill which affronts and assaults the basic structure in such a direct manner? It completely defies any comprehension.
Sir, I'll ask you a final question. So till now, the opposition calls all of this diversionary tactics. Do you just read it as that, or do you think there is intent behind it? That the government will find a way, be it by the virtue of an ordinance?
Diversionary or intent, the implications are very potentious. If this goes through, essentially what you have done, you've altered the fundamental basis of criminal jurisprudence in this country. And that's the worry.
Mr. Tiwari, I really appreciate you taking the time out and joining us, sir. Thank you so much.
Thank you very much.
Appreciate it, sir. Thank you.
Thank you.
All right, viewers, we got you one side of the argument, some of it made inside Parliament, some of it made outside Parliament. But let's get you now the other side. Satyapal Jain, Additional Solicitor General, now joins me live. Appreciate you taking the time out, sir. You just heard our guest there. He made a passionate plea against this particular bill, both inside the Parliament and now outside on my show. The question that I ask you, Mr. Jain, with what is being debated vociferously, is the principle what has been natural justice. An individual is considered innocent until proven guilty. Yet, at least what the new bill seems to suggest prima facie is the removal of a sitting chief minister without being convicted or proven guilty. Somewhere, this is a direct breach of that very principle, sir, of natural justice.
See, in the Indian politics for a very long time, there has been a serious debate as to how the criminals and people with criminal background should be avoided from coming to Parliament, Vidhan Sabha, and they should be kept away from the centers of power. Earlier, under the RPA Act, if you are convicted for a offence for more than 2 years, you would lose your membership, but a privilege was given to the MPs, MLAs, that this clause will not be applicable to them so long as their appeal or revision is pending. Supreme Court struck down that. Supreme Court said all are equal. This should be applicable to MPs and MLAs also. Secondly, later on, the Supreme Court also said that when you file your nomination paper, you must give all the criminal antecedents. Where were you involved? FIR, bail granted, not granted, convicted, not convicted. So this moment of keeping away the criminals from Indian political life, elected officers, is continuing for a very long time. This is a step forward in that direction, that those people, you may be a minister, prime minister, chief minister, if you are detained for more than 30 days in an offence where the punishment is more than 5 years, which are ordinarily the cases of moral turpitude, very heinous criminal crimes, the person himself should have resigned. But since the people are not resigning, I feel it is the right time that this law should be enacted. They should be disqualified from holding that office. But the bill also provides that in case ultimately you are acquitted, or you can become the same position again also when you are clear of the charges or clear of the allegations against you.
Moral turpitude and probity in political life, sir, many would suggest in this day and age has become an oxymoron. But I'll also come to a larger question which is being debated in this day and age of politics, that we are living in a time where constantly the refrain by the opposition is the weaponization of investigative agencies. Doesn't somewhere down the line attempt or risk turning agencies into, like the CBI, like the enforcement directors, into political actors?
No, not at all. Because first of all, let's understand one thing. Maybe CBI, maybe ED, maybe SFIO, they prosecute people against whom there are serious allegations. And as per law, any agency arresting any person, maybe a MP, MLA, a common man, a PN or a chowkidar, has to be produced before the trial court or the appellate trial court or the session judge, CGM, whatever it is, within 24 hours. So first of all, after the arrest, it is the court which examines whether there are sufficient grounds for sending him to police custody or judiciary custody. After that, there are now under the PMLA, under various other acts, Supreme Court has gone even to the extent that when you arrest a person, give him the reasons in writing. Why are you arresting him? Then you have the best available lawyers available to you for getting bail, etc., etc. If you are not able to get bail, it means the court finds that there are serious allegations against you. Let's not forget, after the arrest, repeating it, after the arrest by any agency, it is the court which decides whether to send you to jail or bail or remand or whatever it is. So therefore, the moment you are arrested, you are under the supervision of the judicial officer. You cannot blame the executive or the investigating agencies for keeping you in jail. That is the judicial discretion exercised by a judicial officer. So you can't say that it's something vindictive or it's just to put the people of the opposition parties in jail. Well, if you have committed crime, if there are serious allegations against you, only then judiciary will send you to jail. And if the judiciary has sent you to jail, you have no moral right to remain in power because there are serious allegations against you and you should not remain in that position. Only minister, PM and all that. Your membership doesn't go. You continue to be a member. It doesn't take away your membership. Only the power. And let's not forget, in 1998, when Mr. Lal Krishna Advani's name was there, mentioned in Hawala, immediately the moment he came to know of it, he resigned from Lok Sabha and said, unless I am cleared by the Hawala court, I will not contest any election. Mr. Madanlal Khurana was the Chief Minister of Delhi. He resigned the moment his name was mentioned in Hawala. Mr. Yashwant Sinha, now he is in opposition. He was leader of the opposition, BJP in Bihar Vidhan Sabha. The moment his name was mentioned, he resigned from the opposition, leadership of the leader of the opposition. Such are the moral standards which people have to set in public life. And I think those who are facing such criminal charges should immediately be removed from the office of the president, of the minister. And Act says so. Amendment says that either you resign within 30 days. If you do not resign, then 31st day you have to go home.
But Mr. Jain, the fact is you talk about the judiciary sending one to jail and it must be big enough. But there are certain archaic draconian laws like the PMLA which tie the hands of the judiciary. Laws that are being contended and contested in court as we speak. Where if you are arrested by the ED, the onus is on you to prove your innocence, number one. Where you can be kept in custody for 30 days straight without getting bail. Today we are talking about the PMLA which, which I just told you, sir, that you can actually be kept in jail for 30 days before you're even considered for bail. By that time, the chief minister or the minister will need to step down.
No. Please don't misunderstand the law. PMLA says in case you arrest a person under the PMLA, you have to convey him the reasons of his arrest, grounds immediately within 24 hours. And they are produced before the court when the court decides whether to remand you to judicial custody or to give the remand to ED or to release on bail. All powers are with the judiciary. Let's be very clear. After arrest, maybe by the ED, maybe by the SFIO, maybe CBI or police, the next step is by the judiciary. It is they who decide whether to send you to jail or not. So therefore, don't think, let's not remain under the impression that the government will arrest and put you behind the bar. They can do it only within 24 hours after arrest. They have to get the remand from the judicial officer.
But sir, I'm yet to...
It is a special court. The officer is of the ADJ district judge level, additional district judge level, or chief judicial magistrate. So I am very clear. This is a good step taken in the direction of cleaning the political life, Vidhan Sabha, Parliament, from the people having criminal antecedents.
Mr. Jain, correct me if I'm wrong, because I don't know a single case in recent memory where somebody who was charged with PMLA was given bail by the judiciary in less than 30 days. The law is so archaic and draconian, facets of which are being contested in court on the very fact that, like I said, I don't remember anyone who's been given bail in less than 30 days, sir. You gave me some examples of LK Advani ji. That kind of moral turpitude doesn't quite hold in this day and age. At least we haven't seen it. Let me give you examples of certain chief ministers and leaders who've suffered at the hands of being in jail and maybe having to fight an election. Ms. Jayalalitha, Shibu Soren, A. Raja, Jagannath Mishra, all eventually acquitted by the top court. How fair do you think, sir, it is to remove a sitting chief minister who's been in jail and later is acquitted? And some of them have fought elections while they were in jail. Their parties definitely have.
Out of hundreds of the former chief ministers, center minister, you are pointing out only 4 or 5 names against whom there were serious allegations. And let's not forget about the basic principle of criminal law. If there is a doubt, you are booked. If there is a doubt that you have committed an offence, you are booked. And if there is a doubt, ultimately you are acquitted. Sometimes you are acquitted by giving the benefit of doubt. In public life, these are the leaders who are leading the public, who are setting example for the nation, who have to lead the nation, who have to lead the public. If they are facing such criminal charges, I personally feel they have no moral right to remain in power. Is this bill aims at making these people alert that look here, it's a warning to them also. All people who are in power, that if you do such type of things, it is at the risk of losing your membership, your ministership, your chief ministership. And let's not forget, hundreds and the hundreds are there against whom there are no allegations. Bad example will never make any law bad.
But Mr. Jain, there is a huge distinction on facing criminal charges and actually being, convicted of those criminal charges. So recent history, sir, clearly demonstrates how opposition leaders have been arrested, held in custody for very long periods of time, only to be discharged later, especially in states where the chief minister is getting into an election. To take in the leader of that party and the chief minister, arresting him, and then later on, if he gets bail, to put him back in the chair doesn't quite hold. You might call it want of evidence, but on the contrary, some of them have been acquitted completely.
Madam, this is applicable not to the MLAs, MPs. This is applicable amendment to the ministers, the chief minister, including the prime minister. Including the prime minister, this law says it applies to him also. And if there are very serious allegations, you don't remain in office as a minister, where you are supposed to lead the department. You take oath in the name of defending the Constitution of India, believing in the rule of law, that you will defend the law, the rule of the Constitution. Then you are yourself an accused of a serious offense. Then what right have you to remain in power? You should yourself withdraw from there. You should yourself resign from there, so that you set a good example. Now, so far as the amendment is concerned, if it is enacted, it will be now for the courts all to see whether this man should be sent to judicial custody or not, whether he should be sent to jail or not. You don't send, the government doesn't send a person to jail. The government or CBI or ED doesn't send any person to jail or custody. It is the court which does it. And if you don't have faith in the court, if you don't have faith in the judiciary, then I'm sorry, I can't comment on that.
No, sir, it has nothing to do with me. I'm giving you the call of what the opposition is saying. For example, the claim which has been made by Arvind Kejriwal that this is exactly what the BJP wanted. You tried to do exactly that, which is the BJP here, to make him and push him to resign. You couldn't do that, where he insisted on running his office from jail. Now, again, I'll come back to the PMLA here. Not just the likes of Arvind Kejriwal, the likes of Hemant Soren, individuals taken into custody, denied bail for over 30 days, multiple accounts coming out in the case of Hemant Soren, been acquitted, but being forced to fight an election with the taint of being guilty, which you are not ultimately, at least in the case of Hemant Soren.
Oh, no, not at all. Because once again, I am repeating, I am not aware of any clause that you will not be given bail for 30 days under the PMLA. I am not aware of it, any clause which you are mentioning. But
sir, I've given you the example of Mr. Hemant Soren. There's an example of Manish Sisodia. There's an example of Arvind Kejriwal. It happened with Shibu Soren as well. Multiple examples, sir.
It doesn't mean that simply because you are an MP or MLA, no action should be taken against you whether you are convicted, not convicted, charge-sheeted, not charge-sheeted, you are above law. Nobody is above law. An IAS officer who remains in custody for 24 hours or state public servant, is he not suspended immediately thereafter?
Fair point.
Why? He can also say the same thing, and every criminal will say, so long as I am not convicted, I am not guilty. It's not the question of convict or innocent and all that. It is the question of public morality. If you are facing such serious chances that the court also wants you to retain in jail, you have no right to remain in
public morality is something which really is non-existent. It's an oxymoron in political life, at least as of now. But you make a very fine point where you talk about, because the same yardstick is applied to civil servants, why are our politicians any which way special? I'm going to come back to now whether or not this bill will be passed or not, sir. The larger question now will be the passage of this bill, which requires 2/3 majority for the bill to be passed. Correct me if I'm wrong.
I think it's a constitutional amendment. I think it will require, but when it goes to JPC, I have been in parliament twice. JPC examine all the bills which are sent to it rising above party politics. They will examine each and every clause, suggest the amendments also. Then the report will come to Parliament. I think it will require two-thirds, but I can't say because I have not checked up just now the constitution. It might require due procedure will be followed by the present government while enacting the bill. Discussion, JPC discussion, report in Parliament, voting, everything will be done as per the requirement of the constitutional law. No law will be bypassed.
But due procedure would also mean, sir, by the virtue of ordinance, there was a departure that was seen in the abrogation of Article 370 in 2019. That time the excuse was taken that it was a special temporary provision in the Constitution. Therefore, simple majority clause was used, enabling for implementation of the constitutional amendment. However, in this case, do you see any other legal loophole, sir, that could be exploited?
If it is two-third majority, it is two-third majority of the present and voting, but simple majority of the total house. Two-third of the present and voting, and simple majority of the entire house. And I'm reminding those people who are opposing it, they are saying two-third and all that. They should not forget in 75, when they took away the right of hundreds of MPs, thousands of MLAs, lakhs of people, keeping them in jail without bail, without trial.
But sir, that's a political argument that you're making, aren't you? I'm talking about the legality of it.
As per the constitutional requirement, bill will be passed, and when it will be passed, it will be before the whole world. Parliament proceedings are live telecast. It can't be done in a secret manner.
All right, sir. Fair point. Appreciate you joining us, taking the time out. Thank you, Mr. Jain, for joining us on that. With that, viewers, let's quickly shift focus. We have a special guest this evening. The US ratcheting up pressure in India. Repeatedly, one after another, Trump administration officials have come out in the open criticizing India over its ties with Russia. You have President Trump trade advisor Peter Navarro, US Treasury Secretary Scott Bessent, and then White House Press Secretary Caroline Leavitt. All of them have alleged that Indian arbitrage of Russian oil is unacceptable, underlining Washington's stand that New Delhi was fueling Moscow's war economy. My first question, sir, and I want to take it off from the meeting of President Trump with President Putin. Now, President Trump, Mr. Bolton, laid out, if one can call the red carpet, welcomed Putin in Alaska, a military flyover, a ride in the presidential limousine, completely courted Putin, possibly ending his international isolation. According to you, Ambassador, did Putin clearly have the upper hand? Something which has been criticized by Trump, of your opinion.
Yeah, I think Putin has been able to reestablish in Trump's mind that they're friends again, and Trump sees international relations through the prism of personal relations. And I think Putin has demonstrated again his KGB agent training in his efforts to manipulate Trump. So I think that the Russians have escaped Trump's threat of additional sanctions or additional sanctions on purchases of their oil and left India as the only country, not China, not Russia itself, not Turkey, not others, that have been subjected to sanctions. To be clear, I think the purchase of Russian oil and gas is something India should move away from. But part of the problem here is the way the sanctions themselves have been set up. And if Navarro and Bessent have trouble with that, there are things they can do to change the sanctions and then give India a chance to comply.
Well, Ambassador Bolton, I'm glad you're saying it for what it is, as sanctions and not tariffs, of what is the official communique on that. But taking off from the meeting with President Trump and President Putin, now, one thing is very clear: there is no ceasefire yet. Talks will have to take place even as the war is on. Putin seems to have made it very clear, and it's evident that his peace plan is practically exactly the same as what was the original Kremlin stand. So nothing really has changed where Putin comes from.
No, Putin hasn't changed a bit. His objective is still to reincorporate Ukraine into a greater Russia, to recreate the Russian Empire. Putin's been telling us this publicly for 20 years. No surprise.
Now, Now, do you see President Trump here completely blinded by possibly the lure of a Nobel Prize being manipulated by President Putin?
Well, I think everybody's trying to manipulate him. They can all see that he wants the Nobel Peace Prize, but I think the European leaders and Zelensky came to meet with Trump on Monday to try to provide a vaccine or an antidote to the meeting with Putin in Alaska the Friday before. And I think this is now going to go back and forth. I don't see any substantive change by anybody. And I don't blame the Ukrainians. If I were in their shoes, I wouldn't concede anything either. But I don't see the basis on which negotiations can proceed. What Trump wants to do is kind of bounce everybody into an agreement that he can then take credit for. If it falls apart later, I don't think he's so worried about it. He can then blame it on other people. But he wants this to add to his list of accomplishments, like solving the a conflict between Pakistan and India a few months ago, that make it 7 wars out of 7 this year that he's ended. The record doesn't demonstrate it, but this is Trump, the PR expert, trying to campaign for a Nobel Prize.
You know, because if you did look at it, Ambassador Bolton, and maybe you can weigh in on it, because it did seem that President Putin wanted to talk about everything else but Ukraine. He really did not want to address the situation in Ukraine. He's very happy the way things are, it seems.
Well, I think he is, but what he proposed to Trump by many reported sources is he demanded the cession by Ukraine of about 1/3 of the Donetsk province, a big part of the province that the Russians haven't been able to conquer, which I think Putin knows is unacceptable to Zelensky and the Ukrainians. So he's trying to put them in the position of being the party that obstructed Trump's peace efforts. You're quite right that he really wants to talk about the bigger picture, the overall relationship with the United States, because he thinks that puts himself in a better frame in Trump's view.
Right. But Ambassador Bolton, because where ceding of any land is concerned, it would require a referendum back in Ukraine. Politically, at least right now, it could be impossible. Or do you think it's a different play field?
No, I think the Zelensky government would be in real trouble if it gave up any substantial portion of Ukrainian land, even in just a ceasefire. Not talking about sovereignty questions here, at least in the near term, but just what happens in an interim ceasefire or truce while negotiations go on. I think Zelensky would be hard-pressed to give up anything. It's true that polls in Ukraine show a very, very large percentage of people want to have peace. Why wouldn't they after 3.5 years of attacks on their civilian population by the Russians? But equally high numbers show that they don't think that Russia's aggression should be rewarded.
Ambassador Bolton, you know, European leaders that we saw sought security guarantees for Ukraine, very similar to Article 5 of the NATO treaty, which would mean any attack on Ukraine will invite retaliation from NATO countries. However, you have President Trump that's clarified in an interview that it cannot be NATO. Trump has added that US troops won't be stationed in Ukraine. Has he once again, somewhere down the line, thrown Europe under the bus?
Well, I think it has been his position and reaffirmed this week as well that he doesn't want American boots on the ground in Ukraine. It would have to be Europeans. And although there was some talk of American air power, it's very unclear whether Trump means American combat aircraft or American cargo aircraft to carry in supplies for whatever European may be on the ground. This is all very unclear. And it shows why, despite all the diplomatic effort, all the pomp and circumstance on the substantive questions of how a truce or a final agreement would look like, they're just nowhere near it.
Ambassador, I was reading your opinion piece after the Alaska summit. You seem to have argued that Ukraine needs now firm assurances of continued US and European military aid. Trump has since said security guarantees would come from Europe in coordination with the US, ruling out ground troops but leaving open the option of air support. Do you believe this approach can realistically work, or do you think it's a far cry?
Well, I don't think Trump is fully aware of exactly what he's promising. I mean, he has said on the positive side that we would continue to sell equipment, weapons, ammunition, and the like to Europeans who could then pass it on to Ukraine. But this is hardly the kind of role that I think it's appropriate and important for America to play to help Ukraine on the strategic side so that they can put themselves in a better negotiating position. And I just don't think Trump's thinking through the specifics.
But, Trump is known, Ambassador, for his transactional diplomacy, especially in the recent past. Ukraine has offered now to buy arms worth $90 billion. Will that sway him?
Yeah, I think he's very happy about that, but I think he recognizes that he still hasn't brought the two parties closer together. And in fact, this morning in Moscow, Russian Foreign Minister Sergei Lavrov was quoted as saying that Russians are not going to accept any security guarantees or forces in Ukraine that they haven't participated in helping to shape. Now, that's a pretty outrageous demand, but I think it also shows once more that the Russian position is just as firm as it was before last Friday.
Ambassador, I'm just going to take 2 or 3 questions from you regarding the geopolitics of it and implications of it where India is concerned. Now, experts seem to suggest that U.S. President's tariff, along with perceptions of a very diminished American role in the Indo-Pacific partnerships, have accelerated efforts to stabilize an India-China relation. In the past, and you'd know that Washington has actively encouraged India to counterbalance Beijing in the region. Now, how do you view the recent thaw in India-China ties? Of course, we are coming off Operation Sindoor, where we actually thought we fought a proxy battle with China and not Pakistan.
Yeah, look, I think the reaction in India to grow closer to China and Russia is very unfortunate, and that's why this question of the sanctions against India alone, not Russia, not China, not others, pose more problems than they solve. I think you have to look at the long term here, and that is that China is the principal threat in both East and South Asia, and its increasing axis with Russia puts Russia increasingly on China's side. I think that's the strategic future, and I think that's what India should be focused on.
But the hypocrisy of America has put India in a situation where, China continues to buy oil from Russia, but we face tariffs in the form of sanctions. The question I'd like to ask you is, Ambassador, with Trump now imposing sanctions, we'll call it steep tariffs on India, the US-India relation is practically at an all-time low. You previously had called 50% tariff against India a mistake in the bilateral relationship. Can there be a reset in India-US ties?
Well, I think this is a Trump mistake. It's shooting ourselves in the foot, and I think that has to be taken into account. This was no decision endorsed by the U.S. Congress or overwhelmingly by the people. This is part of Trump's effort to win the Nobel Peace Prize, and it's I understand the reaction in India. I do, but again, I think you have to grit your teeth and look longer term here at what I think is the best interest of both countries in the future to have a closer relationship, to worry about the threat that China poses.
Ambassador, my final question, while India-US ties are under strain clearly, there seems to be, which has made us rather uncomfortable, an increasing bonhomie between US and Pakistan. Now, how do you view the US-Pakistan ties right now, and what could be the future geopolitical dynamics of that concerning India?
Well, I think, again, this perhaps stems from the controversy over the terrorist attack in Kashmir and Trump taking credit for resolving and lowering tensions between Pakistan and India. I think a lot of people around the world were concerned about it. I think, obviously, as in the case in 2019 in the terrorist attack in Kashmir, where I participated, these were decisions primarily made by India and Pakistan in their own good judgment. So it's important to try and keep this in perspective, and to remember that Trump is an aberration in American politics. And although we've still got 3.5 years to go, I concede that that's not necessarily the permanent direction of U.S. policy.
Ambassador, appreciate you taking the time out and joining us. Thank you there. We appreciate your time.
Thank you for having me.
An exclusive conversation with India Today, Sachin Tendulkar's daughter, Sara Tendulkar, talked about her memories of watching Sachin play and her decision of not taking to cricket. She also shared a piece of advice that Sachin gave her when she stepped into the limelight.
how are you enjoying all the recognition, the popularity, and especially the pap attention that you get, Sarah? How does that feel?
It's definitely something a little bit out of my comfort zone, but I'm getting used to it, and here we are today.
And tell us one like childhood memory that you have when you traveled with your family, and there's something that you did that is still kind of just is special to you.
So, I mean, with my dad playing and traveling to Australia so much, I visited, the first time I ever went was in 1999. And ever since then, I've been going like once in every 4 years. So I have got a lot of childhood memories there, and they were always very happy because my brother and I were very thrilled. We didn't get to see our dad too much because he was always traveling for cricket. So when we'd go there, we were very happy to just spend as much time as we could with him.
Right.
Something that I remember distinctly spending almost every New Year's Eve in Australia in Sydney. So the once in every 4 years New Year's Eve we'd spend in Sydney on a boat with the whole team. So that's something that I will never forget. And also going to the MCG. When I was young, I don't think I realized the significance of the MCG, but now when I went back, all those memories kind of just came flooding back to me.
Amazing. And were you those siblings who used to fight during traveling? Was that the thing?
No, I feel like
Well-behaved
now we fight more than earlier. Back in the day, I mean, he's younger, so I was always very possessive and protective of him. And yeah, I think I just took care of him. Now he takes care of me.
Sweet. And we also have some questions on cricket. So it's clean bowl. We want to clean bowl you on that. Tell me, what's your vivid memory of seeing your father play cricket?
If I have to like pick one memory, it would be his retirement match. So that one, I mean, I was old enough to really understand what that meant. But yeah, when I was younger, I don't think I really, I mean, I went for the game, so I do have memories, but I never really grasped it as much as I did when he was retiring.
Right. And with your father and of course brother playing cricket, you never wanted to pick up the bat?
Never. It's been my brother's forte. Played like gully cricket, but never proper, never.